Reading and approvals of the minutes of the previous meetings. We now proceed to the reading and approval of the minutes of our meetings last September 17 and November 2025.
Mr. Chair, motion to dispense with the reading of the minutes of the previous meeting and for the approval of the same.
Second, Mr. Chair.
Any second?
Second, Mr. Chair.
There is a motion duly seconded to dispense the reading of the minutes of the previous meetings and for the approval of the same. Any objection? Hearing none, the motion is carried. The chair acknowledges the presence of the following members of the committee. We have today with us Congressman Dean Asistio of the 3rd District of Caloocan. From the 4th District of Bukidnon, Representative Laarni Labin Roque. From the Trabajo Party List, Representative Joanne Monique Bautista. From One Tahanan Party List, Representative Nathaniel Educado. From the 3rd District, South Cotabato, Representative DB Estuan. Yan na. So we thank our resource persons for joining us today. As your names are mentioned, please stand to be acknowledged. Comsec, please read the name of our resource person.
Thank you, Mr. Chair. Good afternoon. Today we have the following guests. From the Department of National Defense, Senior Undersecretary Erineo Espino.
Andyan.
Okay. Attorney Leonardo Calderon III. From the AFP, we have Colonel Lex Michel Dapanas, Colonel Ralph D.C. De Mesa. From the Department of Foreign Affairs, we have Assistant Secretary Robespierre Bolivar, Mr. Archimedes Villar, and Ms. Joarlene Espirito. From the DOJ, we have Senior State Counsel Freddy Ganchoon. From the DICT, Department of Information and Communications Technology, from their Cybercrime Investigation and Coordinating Center, we have Chief Cleo Dongaas, Arnold Gundran, Giancarlo Christie, from the Philippine National Police, we have Police Brigadier General Frankie Candelario, Colonel Artemio Recabo, and Colonel Ron Quixote. From the National Bureau of Investigation, we have Director Ferdinand M. Lavin, Supervising Agent Christopher Hernandez, and Agent Anthony Alfred Vita, and also with them are Senior Agent Patrick Vincent Pasis, and Mr. Kennedy Del Rosario. Okay. From the National Security Council, we have ADG Cornelio Valencia Jr., Attorney Camille Angelica Gonzalez, Mr. Richard Manrique, and from the NICA, We have Attorney May Arcelias. From the Commission on Human Rights, we don't have, okay. From the National Privacy Commission, we have Attorney Mary Kate Clarice Marcelo. From the UP Law Center Institute of Government and Law Reform, we have Professor Neil Silva, Attorney Maria Yolanda Haveliana, with their research assistants, I believe. And additional guests from the Philippine National Police, we have Colonel Dominador Matalang, Colonel Jose Nahera, Colonel Pablito Asmod, Captain Marvin de la Cruz, Colonel Alexander Lorenzo, and Police Major Ronan Villagonzalo. Okay. May habol na. That's all, Mr. Chair. Thank you.
We would like also to acknowledge the presence of our representative from the 3rd District of Pangasinan, Representative Maria Rachel Arenas. Good afternoon to our colleague, our resource persons, and other guests. We gather today to confront an issue that goes to the heart of our democracy, foreign interference. Let me be clear. This is not about diplomacy, and it is not about legitimate engagement between or among sovereign states. This is about covert and deceptive action by foreign actors intended to influence our democratic process, our institution, and the decision of our government without the consent of the Filipino people. Sa simpleng salita, ito'y panghihimasok sa ating soberanya. Foreign interference today is sophisticated. It operates quietly through disinformation, digital platforms, financial channel, and influence networks. It is harder to detect, the more dangerous to ignore. Kapag hinayaan natin ito, unti-unting mawawalan ng tiwala ang mamamayan sa demokrasya at sa ating pamahalaan. Our existing laws address parts of the problem, but some were crafted for a different time, while the more recent ones are not enough to meet a threat that is organized, transnational, and technologically driven. Our hearing today is the committee's initial step into ensuring that we have a strong, clear, and fair legal framework. Layunin nating makabuo ng isang batas na mariing magtatakda ng matibay na panuntunan upang labanan ang banta ng foreign interference, ngunit may paggalang sa mga karapatang nakasaad sa ating saligang batas. Mayroon ring 6 na foreign interference bills na nakarepair sa ating committee. In a while, we will be requesting the distinguished author of the bills for their sponsorship remarks. After that, we will ask our resource person for their documents. We call on you, our partners, to speak with candor and responsibility as we work to protect our democracy for this generation and the next. Thank you. Now we proceed to the consideration of the bills. For purposes of orderly proceedings, the committee secretary shall read the number, title, and author of each bill, upon which reading the author or a representative shall be recognized to deliver the sponsorship remarks of the appropriate motion. So the committee secretary is now directed to proceed to the measure.
Thank you, Mr. Chair. The first bill is House Bill number 1068, an act to regulate foreign influence and address covert, undesirable, and malign foreign influence and foreign interference. For this purpose, instituting resiliency measures and the institutionalization and institutional reforms, and for other purposes, authored by Representative Maria Rachel Arenas.
May we hear Representative Arenas for his message.
Thank you, Mr. Chair. Mr. Chair, distinguished members of the Committee on National Defense and Security, I present House Bill number 1068 as a protective and resilience building framework for Philippine democracy. This measure recognizes that modern threats to sovereignty are not always overt acts of aggression. They can take the form of deception, manipulation, disinformation, economic leverage, and covert political influence that quietly erode public trust and institutional integrity. For this reason, the bill goes beyond traditional penal approaches by seeking to protect our people, our institutions, and our democratic processes from covert, undesirable, and malign foreign influence through clear definitions, calibrated enforcement, transparency mechanisms, public education, and institutional reforms that strengthen our capacity to detect, resist, and counter harmful activities while safeguarding constitutional freedoms and legitimate international engagement. This proposal is grounded in both research and lived Philippine experience. Independent studies have warned that our electoral, legislative, and subnational governance processes are especially vulnerable to malign tactics, and recent developments have shown how foreign influence can enter through opaque arrangements, digital disinformation, and illicit activities that have raised serious national security concerns. House Bill 1068 responds to these realities by regulating foreign arrangements, strengthening interagency coordination, and building public resilience, all while keeping the door open to genuine cooperation and lawful foreign engagement. This bill attempts to address a complex and evolving challenge, and I welcome the valuable inputs of relevant government agencies here today, security experts, constitutional scholars, and civil society to further refine it. Thank you very much, Mr. Chair.
Thank you, Your Honor. The next bill.
Mr. Chair, number 2 in our list is House Bill number 3219, an act penalizing foreign interference in the Philippines and creating the Counter Foreign Interference Task Force and for other purposes by Representative Binky April Tupas.
Mr. Chair, I move that the explanatory note of the House Bill 3219 be adopted as the sponsorship remarks of the author.
Second, Mr. Chair.
Any objection? Hearing none, then House Bill number 3219 by Representative Tupas. We are adopting the explanatory message. House Bill number 4214.
Sir, House Bill number 4214, an act penalizing foreign interference in the Philippines and creating the Counter Foreign Interference Task Force and for other purposes by Representatives Oscar Malapitan, Roman Romulo, Ramon Rodrigo Gutierrez, Nathaniel Odocado, and Joan Monique Bautista.
Mr. Chair, I move to adopt the explanatory note to serve as the sponsorship remarks of the said authors of the bill.
Any objection? Hearing none, then we are adopting the sponsorship speech or the explanatory message.
Mr. Chair, number 4 is for House Bill number 4887, an act prohibiting foreign interference and providing penalties for violations thereof, creating for the purpose the Counter Foreign Interference Task Force by Representative Carlos Andes Loria.
Mr. Chair, I move that the explanatory note of House Bill 4887 be adopted as the sponsorship remarks of the author.
I second the motion, Mr. Chair.
Any objection? If none, we are adopting the explanatory message.
Next bill, Mr. Chair, is House Bill number 4890, an act penalizing foreign interference in the Philippines and creating the Counter Foreign Interference Council and for other purposes by Representative Steve Chiongbian Solon.
Mr. Chair. On behalf of the sponsor of House Bill number 4890, as introduced by Representative Steve Chiongbian Solon, may I move that his explanatory note be adopted as the sponsorship remarks of the author. Thank you, Mr. Chair.
There is a motion duly seconded to adopt the explanatory note of all the bill as the sponsorship remarks of the author. Any objection? Hearing none, the motion is approved.
Mr. Chair, the last bill is House Bill number 7200, an act regulating foreign influence, penalizing foreign interference, and creating the Counter Foreign Interference Council, providing measures for national resiliency and for other purposes by Representative Alexander T. Pimentel.
Mr. Chair, I move that the explanatory note of House Bill number 7200 be adopted as the sponsorship remarks of the Honorable Alexander T. Pimentel.
And second,
Second, Mr. Chair.
there is a motion duly seconded that we adopt the explanatory message of the said measure. Nana. So may we now hear the comments of our resource person? Or you can give your comments upon being recognized by the chair. So before that, I would like to acknowledge the presence of Representative Roman Romulo of the Lone District of Pasig, and again, Congress Representative Steve Salun, Chiongbian Salun. Thank you. Sino magbibigyan ng kailan? The floor is now open for questions or comments from the members and further remarks from our resource person. Hayaan po ninyong mauna na ako ang magtanong sa ating mga resource person. Department of National Defense. Hindi ito yung question. Ha? Ha? Pagsalitahin natin. So before that, would like to hear from the Department of National Defense, Senior Undersecretary Reneo Espino. Ha? Wala. Attorney Leonardo Calderon, Director for Legal and Legislative Affairs Service.
Good afternoon, Your Honor. The department submitted its comments only this week. Allow me to read it before this body. The department fully supports House Bill numbers 1068, 3219, 4214, 4887, and 4890, which seek to establish a comprehensive framework that would enable the government to detect, prevent, and penalize acts of foreign interference and covert influence. In this regard, the department recommends the inclusion of a provision expressly conferring jurisdiction upon the General Court Martial over offenses under the proposed measures when committed by members of the Armed Forces of the Philippines. That's it, Your Honor.
From the Armed Forces of the Philippines, AFP, may we hear from Colonel Lex Michel Dapanas.
Mr. Chair, honorable members of the committee, good afternoon, sirs and ma'am. The Armed Forces of the Philippines, thank you for the opportunity to appear before this committee and to contribute on your deliberations on the proposed Foreign Interference Act. The foreign interference and malign influence, often called FIMI, is not a distant or theoretical concern. It's a real and accelerating national security threat that increasingly operates below the threshold of armed attack. It targets our decision-making, our public perception, our policy outcomes, and ultimately, our sovereignty. These operations frequently through disinformation, covert influence networks, cyber-enabled operations, illicit finance, and proxy actors. What makes this threat especially dangerous is that it often does not look hostile at first glance. It enters everyday channels, relationships, narratives, incentives, and digital spaces, then works to fracture trust, polarize communities, and pressure public institutions. It thrives in gaps in awareness, gaps in coordinations, and gaps in public resilience. From the AAP perspective, our responsibility is clear and constitutional to support the state in safeguarding sovereignty and security while remaining firmly guided by civilian supremacy, the rule of law, and respect of others. In that spirit, this proposed measure is important because it aims to establish three things that are essential for an effective and prosecutable response. Number one, a clear definitions and thresholds, so legitimate speech and lawful advocacy are protected, while covert, deceptive, coercive, or corrupt foreign-directed conduct is penalized. Number two, a whole-of-government coordination mechanism, so information is fused, roles are clear, and response is synchronized. And number three, a case-buildable evidence pathway, so intelligence lead can be converted into admissible evidence with the proper chain of custody, due process, and judicial oversight. Finally, sir, I wish to underscore that this challenge cannot be met by the government alone. It requires a whole of society effort involving the government, the civil society, the academe, the private sector, and the international partners, because the battle space is not only in physical, it's also informational, cognitive, and financial. Mr. Chair and honorable members of the committee, the AAP stands ready to support the Congress and the appropriate civilian agencies in building a framework that is strong, implementable, prosecutable, and fully consistent with constitutional rights. Thank you, sir.
May we hear from the Department of Foreign Affairs, Assistant Secretary Bolivar, Office of Policy Planning and Coordination. Ayan.
Thank you, and good afternoon, Chair. Good afternoon, Your Honors. The Department of Foreign Affairs submitted its position paper on the pending House bills, in late November of last year, and we submitted an updated position paper sometime early this week. But if, with the indulgence of your honors, I'll just mention that the Department of Foreign Affairs supports the passage of a comprehensive legal framework to counter foreign information manipulation and interference, as this is engaged in covert, deceptive, or coercive activities intended to manipulate Philippine political processes, information ecosystems, national policies, and societal cohesion. We also support the creation of the Counter Foreign Interference Task Force, and we mentioned our support for the designation of the Executive Secretary as chair of this task force. As far as cooperation with like-minded states is concerned, the Department of Foreign Affairs has been beginning its benchmarking exercises with many countries so that we know and learn from their respective experiences in countering foreign interference and malign influence. Thank you, Your Honor.
Okay, thank you. From the Department of Information and Communication Technology, may we hear from Giancarlo Cristi?
Thank you, Mr. Chairman, and good afternoon to the honorable members of the committee. First of all, we would like to take note of the role of the DICT as prescribed under the legislative measures. Number one is the core membership in oversight bodies that the DICT or the Secretary of Information and Communications Technology is designated as a key member of either the Counter Foreign Interference Task Force or the Counter Foreign Interference Council. Number two is the participation in technological subgroups. That the DICT is part of specialized subgroups or focus programs within the task force or the proposed council concentrate on the technological dimensions of foreign threats. These groups are tasked with implementing actionable plans, conducting risk assessments, and recommending policy adjustments to address emerging digital dangers. Number three is strengthening cybersecurity, a primary functional responsibility of the Department of Information and Communication Technology. And as part of this body, will strengthen cybersecurity measures specifically to protect critical infrastructure and digital systems from foreign interference. And lastly, interagency coordination, that in certain versions of the legislation, the DICT is tasked with coordinating with other government agencies that have shared responsibility for cybersecurity to ensure a unified effort in protecting the country's digital assets from foreign malign influence. As an initial manifestation, the Department of Information and Communications Technology supports this proposed legislation, which modernizes the country's legal framework to address hybrid threats such as disinformation, cyber operations, and covert political influence. The bills promote a whole-of-government approach through mechanisms like a Counter-Foreign Interference Task Force or Council to strengthen the detection and prevention of foreign interference. The DICT affirms its commitment to work with other government agencies, and we will submit our official and final position paper in support of this measure. Thank you very much.
May we hear from the Philippine National Police, Police Brigadier General Frankie Candelaria.
Thank you, sir. Mr. Chairperson, distinguished members of committee, ladies and gentlemen, good afternoon. As affirmed in the 1987 Constitution, the state shall pursue an independent foreign policy with national sovereignty, territorial integrity, and the right to self-determination as paramount considerations. In this context, the Philippine National Police recognizes that foreign interference poses a direct and evolving threat to national security and public order. Accordingly, the PNP fully supports the passage into law of legislative measures addressing foreign interference as embodied in House Bill numbers 3219, 4214, 4887, 4890, 1068, and 7200. From a law enforcement perspective, foreign interference presents a clear threat to public order and national security. Existing laws do not comprehensively address this danger, thereby limiting the ability of authorities to promptly investigate, disrupt, and prosecute such activities. The proposed measure closed this gap by clearly defining and penalizing foreign interference in its various forms, including preparatory acts, conspiracy, and proposals. The proposed creation of the Counter Foreign Interference Task Force is likewise critical. As a member of the task force, the PNP will be better positioned to coordinate intelligence, investigations, and enforcement actions with concerned agencies under a unified national strategy. The PNP stands ready to contribute its expertise in investigation, intelligence, risk assessment, and enforcement, and to work closely with partner agencies to translate policy intent into operationally effective and constitutionally sound measures. In closing, we affirm the PNP's commitment to safeguarding the Filipino people, protecting democratic processes, and supporting this honorable committee in crafting legislation that is firm against foreign interference, balanced in its safeguards, and effective in its implementation. That's all, sir. Thank you.
Investigation. Now, may we hear from the NBI, National Bureau of Investigation, Director Ferdinand Labing.
Good afternoon, Your Honors, Mr. Chair. The NBI wishes to express its full support, and Attorney Angelito de la Paz Magno, the NBI Director, would like to convey his thanks to this committee for allowing us to participate. We will be submitting, Your Honors, Mr. Chair, our position on the matter before the conclusion of today's scheduled committee hearing. Essentially, however, our position is for the inclusion of the NBI in the task force. While there are, I've seen some harmonizing effects, this should be taken up, Mr. Chair, I believe, in the discussion proper of the different bills. The NBI, to note, has conducted series of operations last year, around 6 or 7 operations, and we find the existing pieces of legislation antiquated, if not inadequate. But just the same, the NBI was able to prosecute them, and they arrested foreign nationals. I do not want to sound, Mr. Chair, discriminatory. These are Chinese nationals, are still in jail. We used the available pieces of legislation. We would like to thank again this committee that they should help law enforcement in its predicament, addressing the various acts as to be defined under the foreign interference bills. Thank you, Mr. Chair.
Security. May we hear from Assistant Director General Cornelio Valencia Jr.
The Honorable Oscar Malapitan, Chairperson of the Committee of National Defense and Security, distinguished members of the committee, and to our colleagues in the national government, a pleasant afternoon to all. Foreign interference and malign influence are present in ways that often appear harmless. They rarely announce themselves. They do not always look hostile. Instead, they capitalize and enter quietly through relationships, narratives, incentives, and everyday decisions. In our jurisdiction, we have witnessed effort to shape public narratives and divide opinion, pressure exerted on public officials, and cases involving covert activities. These incidents span political, informational, economic, technological, and even community-level engagements. Often, each incident may appear isolated or manageable on its own, but together, They form a more complex interference landscape that demands vigilance and coordination, as well as legislation. The challenge before us is to ensure that we and our institutions can clearly recognize, discern, disrupt, and dispel any forms of malicious interference, malign information, and influence through a clear and effective legislation. We fully support the consolidation of House Bills number 1068, 3219, 4214, 4887, and 4890 into a single law. There is urgency in this law. Our shared task is not to limit foreign engagement nor avoid it, but to build resilience so that our foreign engagements remain transparent, informed, and aligned with our national interests. Maraming salamat po.
National Intelligence. May we hear from the National Intelligence Coordinating Agency, or the NICA, Attorney Mae Arcillas.
To the Honorable Chairman and members of this committee, good afternoon. The agency expresses its gratitude for the opportunity to participate in today's initial deliberation on the proposed measures addressing foreign interference. We commend the committee's initiative in recognizing and addressing a modern threat to our democratic institutions, national sovereignty, and security. Foreign interference presents a modern national security challenge, one that does not rely on force of arms, but instead seeks to shape outcomes within our political, economic, and social systems through covert, deceptive, and coercive means directed by or for the benefit of foreign principals. The Philippines is particularly vulnerable to this foreign interference. Our open democratic system, decentralized governance structures, and vibrant civil society, while considered fundamental strengths, can also create points of exposure that may be exploited by hostile foreign states or actors seeking strategic advantage without crossing the threshold of other violent acts. At present, our legal framework addresses threats primarily at the extremes, like treason, rebellion, terrorism, espionage, and the like. These laws, however, are ill-suited to confront nonviolent, covert, state-directed interference that deliberately operates below the level of overt illegality. This creates a critical opening in our national security apparatus, one that House Bill numbers 3219, 4214, 4887, and 4890 seek to address. These bills are intended to expose and deter covert or deceptive collaboration with foreign principals, particularly where such conduct is designed to influence public officials, institutions, or political processes in a manner prejudicial to national security, including through preparatory and enabling acts that often form part of coordinated interference operations. Moreover, the agency supports the creation of a dedicated council on foreign interference to unify the capabilities of intelligence, law enforcement, foreign affairs, cybersecurity, and other relevant agencies, and to strengthen government's ability to prevent, detect, and mitigate its evolving threat across political, economic, technological, and sociocultural domains. The proposed measures also align the Philippines with international best practices in addressing the aggressive interference of hostile states like Australia, Singapore, New Zealand, among others. To this end, the agency believes that these measures will strengthen our ability to protect our sovereignty and maintain our democratic institutions free from foreign manipulations or interference. Thank you very much, and the agency stands ready to support this committee in its deliberation on these measures.
May we hear from the National Privacy Commission, Attorney Mary Kate Marcelo.
Good afternoon, Your Honor and distinguished members of the committee. The National Privacy Commission, or the NPC, submitted their position paper and comments last December 2025, and the Commission supports the passage of the subject bills, consistent with the Commission's goal to protect personal data, facilitate free flow of information, and promote accountability. Thank you.
Okay na? Sino susunod? Ito na? May we hear from UP Law Center Institute of Government and Law Reform, Professor Neil Silva.
Good afternoon, Honorable Chair, honorable members of the committee. On behalf of the University of the Philippines Law Center, we would like to note first that the University of Law Center will submit its final written comment next week, subject to which is currently undergoing finalization and submission for approval. In advance of that written comment, we would like to verbally manifest the substance of our prospective comment. First, we do support the intention of the several bills which have been filed before and are pending before this honorable committee, because as noted by the other persons, resource persons, they are fully consistent with the constitutional imperative to assure our national sovereignty and integrity, territorial integrity, as well as our right to self-determination, which is available as a communal right for Filipino people. Preliminarily, we would like to note some principles that we would like to see highlight moving forward as we discuss on the various bills. First, we believe it is necessary to note to equally protect and balance, number one, our protection of national sovereignty, national security, and self-determination, at the same time to protect the open debate and discussion which realizes the national democratic sovereignty of the Filipino people through freedom of speech. Second, the bill has to be systemic. As noted by the military theorist Clausewitz, the sector, we have to distinguish the governmental sector, the security sector, and the people. And each of these are subject to influence and interference. And therefore, we know that interference and influence have different aspects with different causes. Some due to vulnerability, due to the lack of appropriate education and capacity building. Some because of the increased vectors of influence, such as through new modes of communication, and some because of new channels of interference of influence, such as linkages through commercial and other means. Now, we note that there are three groups of bills. First, House Bill 7200, which is penal in character. And then we have the similarly worded 3219, 4214, 487, 4890, which are primarily penal in character and distinguish the various stages and degrees of participation of foreign interference, and also mandate the organization of relevant coordination bodies. And then we have House Bill 1068, which is the most comprehensive among the bills in terms of subject matter, and does see foreign interference and malign influence as something that requires both penalty measures as well as resiliency measures. We note we note that the House Bill 1068 specifically separates the rules that govern free speech and those that mere speech, and goes that govern acts beyond mere speech, which makes it easier to respond to the real differences between different modes of interference, and also easier to sustain the constitutionality of the bill when it becomes subject to the inevitable constitutional petition and attack. Therefore, to conclude, Your Honors, we note that the different groups of the bills have complementary approaches, some which are penal in character and some are based on resiliency. And therefore, we, as noted by the NSC, as well, it is appropriate to consolidate the various bills, because the ones which are penal in character and provide different modes of commission, and the one 1068 that notes the systemic character of interference and provides resiliency measures as well as transparency measures for foreign arrangements. And we will submit a written comment, Your Honor, next week. Thank you.
Okay, thank you. Yun na siguro ang panghuli. Maliban sa DILG na hindi nakapagpadala ng representative, sulatan na lang natin, hingan natin ang komenta. So maraming salamat po sa inyong pagbibigay ng komento. So the floor is now open for questions or comments from our members and further remarks from our resource person.
Mr. Chair.
So
Sorry, go ahead, Mr. Chair.
So hayaan na po ninyong mauna na ako magtanong sa ating mga resource person. And I would like to address this to the National Security Council. My question is, how does your agency define foreign interference for purposes of your mandate? How is it different from espionage bill? Espionage.
Good afternoon, Madam Chair. I am Attorney Camille Gonzalez, one of the legal officers of the National Security Council. We do have a working definition of foreign interference, although we would just like to put emphasis more on that on our position paper, because that our initial definition came from a working paper. So we have to develop more that definition, but we could give the characteristics of foreign interference, which is mostly covert and manipulative, with the intention of interfering democratic and political processes in a state or harming the interest of one state in another state. So it's both foreign interference and malign influence have the characteristics of covert and manipulative. It is different with espionage because the current definition of espionage under Article 117 of the Revised Penal Code, if I may be allowed to expound more on that, is that the first act of espionage is without authority, a person enters a warship, fort, naval, military establishment, or reservation to obtain any information, plans, photographs, or other data of a confidential nature relative to the defense of the Philippine archipelago. So the intention in espionage is to obtain information which are classified matters with that intention of causing injury to a state or giving advantage to another, which is quite different from foreign interference because in a way, foreign interference works inside a state by influencing the democratic or political processes, whereas espionage is stealing or getting or getting information which are classified matters, which with the current definition relates to the defense of the national government.
From your perspective, how is foreign interference distinguished from legitimate foreign engagement, diplomacy, or cooperation?
Mr. Chair, legitimate influence is allowed by the rules, by international diplomacy rules. Now, the gray area is when there is already an act of coercion or corrupting or deception. That is where interference and malign information comes in. So it is below the threshold of legal actions allowed by international law and diplomacy. That's it, sir.
So may we hear from Representative Arenas?
Mr. Chair, I agree with Mr. Valencia and Attorney Neil that we consolidate all the bills so that we can have a technical working group to address all the similarities and differences. So we have a almost perfect bill, Mr. Chair.
Yes, in a while, we will be appointing the members of the technical working group to study further this bill. Representative Romulo is recognized.
Yes, Mr. Chair. I am in agreement na TWG. Pero just to clarify, sinabi ni Attorney Camille na wala pang formal definition yung foreign interference. There is no formal definition.
Under international law po, wala pa po since even with our counterparts in the UK and Australia, they have their own definition of foreign interference, which is mostly based from the vulnerabilities or specific vulnerabilities that they have in their own countries. We are working on our own po from, we are still drafting, our position paper is still po under process of checking, but we do have we have a working definition there of our foreign interference. It's just that we wish to have to convey more or explain that on our position paper.
Mr. Chair, is there any agency here who has a formal definition already of foreign interference? Since parang may working definition pa lang from NICA, from
NSC po.
yes. Sa iba po, sa ibang agencies present here, do they have their own definition already of what is foreign interference? Meron bang agency na merong definition? Mr. Chair, wala. Could we ask the UP Law Center, kung mayari, kayo, meron ba kayo? Do you have a formal definition?
Your Honor, thank you very much. As noted by the other resource persons, there is no single uniform formal definition of foreign interference, and there are 3 reasons for this. First of all, interference is actually already discussed under the Declaration on Friendly Relations, which includes as one of the unfriendly acts between states. That's the Friendly Relations Resolution of the UN General Assembly. It talks about interference in the political and economic affairs of another country. However, as noted, under the Friendly Relations Resolution, it does not provide a single definition, with rather economic, political, etc., primarily because there are actually various possible ways to conduct interference. For example, as noted in the international experience, Your Honors, there have been allegations that certain countries operate international police stations overseas in other countries' territories, and that is non-speech interference. There are allegations that certain countries create professional or student associations in other countries to manipulate their political processes, which is again something that goes beyond speech. But there are also allegations that certain countries use, for example, bots in social media in order to increase the visibility of certain malinformation or disinformation or misinformation, all of which are different things. Hence the multiplicity of definitions moving forward, Your Honor.
Yes, but is it possible to have a common definition, or is it also, Mr. Chair pala? Mr. Chair, is it difficult to come up with a common definition? Will it be difficult for any of the aides to come up with a common definition? Kasi ang sabi sa atin, iba-iba eh. Maraming ang components eh.
You may respond, sir. And then after that, ADG will respond.
Thank you, Your Honors. If I may, Your Honors, there are 3 possible ways to have a definition. The first way is the one employed in the group of similarly worded bills, which really puts together the different forms of interfering acts, which are both speech and non-speech acts. Hence, deceptive and other acts are also comprehended under a single framework. And this approach is one possibility. The other possibility is to distinguish the various kinds of acts. This is the approach taken in the House Bill 1068, which distinguishes speech and non-speech, one with different rules, with different rules for each, with speech being primarily transparency and interference being primarily suppressive. Okay, and the third one is to look at our current laws, because we do have some existing laws which are relevant to interference. I would like to note, because this was my lecture before for the PPSC. We actually have, for example, existing rules that are similar to interference. For example, CA 616 Section 3 talks about advising insubordination in the armed forces with intend to interfere with, impair, or influence the loyalty of the members of the armed forces of the Philippines. That is in the Espionage Act. However, it is not merely espionage because it goes beyond getting information, but actually includes sending agents of influence, and which is a term of art in security. An agent of influence is someone who acts on your behalf. And another law where this is actually discussed is also same thing. Espionage Act also talks about using interference in times of war. That's CA
Chair?
616 section.
Mr. Chair, para lang mas mabilis.
Yes, Your
Are you telling us, Professor Silva, una sa various measures that are being proposed, it can be divided into 3 categories. Di ba? Parang 3 kinds of foreign interference. In the final version, are you telling us we have to choose one of the 3? Or is it possible 2 of the 3? Or pwede man mapagsama yung 3? Ibig sabihin lahat kami kulang-kulang lang yung definition.
Subject to the other subject matter experts. Looking at it on a broad basis, it is possible to reconcile them because there is possible to reconcile them because we need a comprehensive approach to foreign interference for the purpose of building resiliency. Because to build resiliency, we need to have our officers, both civilian and military and security sector, and also the general public, to be better educated against forms of interference.
Mr. Chair,
Yes, Your
ang
Honor.
sinasabi sa atin ni Professor Silva, it is subject to, of course, yung general consensus amongst all involved. No? What if the consensus is hindi pwedeng pagsama-sama yung 3? Then, kailangan tayo pumili ng 1 out of the 3 or 2 out of the 3. Is that the choice before this committee? Meaning, or do we have to file 3 separate measures? Iba-ibang title na lang.
Thank you, Mr. Chair. I'm subject to the consideration, Your Honors. It may be possible, as noted, to consolidate them with, for example, with different penal clauses for different kinds of interference, and then making a distinction as to the different ways to cause, as noted. Some are conspiracy, some are inciting, for example, and then at the same time have resiliency measures to ensure transparency of foreign arrangements and better public education, better capacity building for the government. Hence, Your Honors, they are actually compatible with different penal provisions for different kinds of interference and different stages and degrees of participation, which some speech and non-speech. And at the same time, Your Honors, the creation of a resiliency measures and the creation of an interagency group that will tackle all kinds of interference and influence. So I do think, Your Honor, but subject to the consideration of the body, that it is compatible, Your Honor.
Mr. Chair, is there anyone here who thinks hindi pwedeng ipagsama sa isang measure yung different subgroups mentioned by Professor Silva? Because sabi niya, subject to consensus of all parties here, di ba? So, is there anyone here who thinks hindi pwedeng mapagsama-sama yung 3 subclasses na minention ni Professor Silva?
Thank you, Chair. Thank you, Your Honors. If I may offer what we put in the DFA position paper, which we submitted in November. This is according to literature offered by the European Union. Among our partners, the EU has issued, if I'm not mistaken, at least 3 policy papers on foreign information manipulation and interference. And this is the definition that they used. I'm not sure if this will please the body, but if I may read from our position paper, quoting the EU papers. Based on existing literature, FIMI refers to efforts to manipulate the information space, is the application of state power on another country, which the latter believes is a contravention of its laws, beliefs, and traditions, is mostly non-illegal but always harmful, manipulative, coordinated, and intentional. It includes the intentional propagation of mis- and disinformation, seeking to co-opt the public narrative and discourse in the target state, usually with the aim of propping up support for the originating state or the state which is conducting FIMI and its positions, or degrading the institutions and policy options in the target state. It's generic, sir, and refers to more the impact of FIMI on a target state. Thank you, sir.
Sir, and you heard Professor Silva describe three separate subgroups. Based on that EU definition, it covers all three.
Sir, I would think it would be generic enough.
Mr.
to
Chair, can we
cover.
ask Professor Silva kung he also agrees?
Based on the discussion, Your Honor, it appears to be comprehensive of all possible forms of interference described.
Thank you, Mr. Chair.
Mr. Chairman.
Thank you, Representative Berman. Would like to acknowledge the Representative Chiongbian Solon.
Thank you, Mr. Chair. Anyway, just to what my colleague Roman Romulo mentioned earlier, it's just my opinion, Mr. Chair, that we should really follow the motion or the instruction of Congresswoman Arenas earlier, that to come up with a technical working group so we can consolidate all these versions. Because upon going through all of them, I think we can come up with a consolidated definition of what foreign interference is. I'm not sure what subgroups Professor Silva was alluding to, but I think you should be part of this group, Professor Silva, so we can come up with a working definition. And I think it's very important we do come up with our definition, because there's obviously not one single official definition, right, as revealed by Congressman Romulo. So, Mr. Chair, I would like to second the motion of Congresswoman Arenas to create a technical working group to consolidate the versions to come up with our substitute bill. Mr. Chair.
Second the motion, Mr. Chair.
So, do you have any motion?
Parang nag-move si Congresswoman Arenas kanina po. Na sinigundahan
for
ko
the
lang.
creation of TWG.
Opo. Yes, Mr. Chair.
So before that, may we hear nalaktawan yata kanina ang representative ng National Security Council, ADG Valencia.
Mr. Chair, thank you very much. What we have to understand is FIMI, like AI, is a new and developing concept. The earliest studies of FIMI came from like-minded countries like the United Kingdom, Australia, which they developed as early as 2015, 2016, and 2017. So as time develops, they came up with respective adjustments in laws. The definition earlier given from the United Kingdom is more focused on the information realm. So we have to understand that definition with their problem on the information space. So interference can be defined depending on the needs of each country, like the definition of Australia is different from what is the definition of the United Kingdom. So it is tailor-fitted on the threats and challenges that we have. So on the question of can it be integrated, the three mentioned categories of Professor Silva is precisely correct. There should be also a part of the law that talks of long-term resilience and addressing current threats. So it is making future-proof that the future Filipino generations would be resilient in malign information and malign influence. Thank you po.
Thank you. So, would like to recognize the Senior State Council, Pret. Get you on. May we hear your comment?
Thank you, Mr. Chair, and good afternoon to you and to the honorable members of the Committee on National Defense and Security, as well as to the honorable authors of these laudable bills. I'm here to convey the support of the Department of Justice for the enactment of a bill focused on addressing foreign malign influence and foreign interference. We also support in making this bill as comprehensive as possible. And in this connection, we support the creation of a counter-interference task force and council, as well as to include in this comprehensive bill resilience measures. We took note, of course, of the comprehensive nature of House Bill 10068. And at the moment, the Department of Justice is just finalizing its comments on these bills. And we are very careful in reviewing the provisions of the bill because, Mr. Chair, this is the first time that we're going to criminalize and penalize foreign interference and foreign malign influence. And so therefore, since this is the first time, we need to be very careful in defining these offenses or these activities that we want to penalize. We must be very clear in the elements of the crime in order to facilitate proper and successful prosecution and in order to make sure that we comply with the constitutional requirement against vagueness or overbreadth in bills, especially in penal bills such as this one, Mr. Chair. I've been listening to the discussion on the definition of foreign interference and foreign malign influence. And yes, there is no single widely accepted definition of this activity. That's because it would depend actually on the threats being faced by a country. So we're looking at, yes, they can be consolidated, these bills. We're looking at maybe providing a general definition, but at the same time, we are very aware that we need to observe the constitutional requirement against overbreadth. We need to be very clear. Vagueness, no, we cannot be very vague in the definition of a crime. So we're still working on our comments on this, Mr. Chair, and we will submit our comments once finalized, and we'll attend the technical working group. Thank you so much.
Okay, thank you. Before we proceed, we'd like to acknowledge the presence of Representative Brian Po. Any other questions or comments on the foreign interference from our members and resource person?
Mr. Chair, may I just,
Representative Arenas recognized.
thank you, Mr. Chair. May I move for the consolidation of all the bills that were presented today, Mr. Chair, and form a technical working group, Mr. Chair.
Okay.
Second, Mr. Chair.
Then we will, any other question? Then we proceed to the creation of a technical working group. The committee hereby creates a technical working group to further study the bills on foreign interference and come up with a substitute or consolidated bill to be submitted to the mother committee for approval. We thank Vice Chairperson Nathaniel Oducado for volunteering to be head of this technical working group. He is handling two significant proposals now. The other is the espionage bill being considered jointly with the Committee on Revision of Laws, where he is assisted by our equally hardworking Vice Chairperson, Arman Panaligan. Do I hear a motion?
Mr. Chair.
Second, Mr. Chair.
Second, Mr. Chair.
You know? Representative Po is recognized.
I second the motion, Mr. Chair.
There is a motion to refer the bills to a technical working group. Duly seconded. Any objection? Hearing none, the motion is approved. We shall now proceed to other matters. Last November 20, 2025, our committee conducted its initial deliberation of the bills that seek to strengthen the Department of National Defense proper, or the DND offices. Apart from the bureaus under it, like the AFP, this is a priority measures of the DND intended to further capacitate the department to ably respond to the growing challenges in defending and securing our country. Presently, there are two bills on the subject, House Bill number 4213 and House Bill number 5107. At this juncture, the committee hereby creates technical working group that will study and submit to the mother committee a substitute or consolidated bill for approval. The TWG will be headed by our esteemed colleague, Representative Arman Panaligan, who likewise volunteered for the job. Do I hear a motion?
So moved, Mr. Chair. Second, Mr. Chair.
There is a motion to repair the D&D proper transformation bills to a technical working group. Duly seconded. Any objection? Hearing none, the motion is approved. Is there any other matters, Your Honor, wish to discuss before we adjourn?
Mr. Chairman, I just like some clarification regarding, sir, regarding the D&D bill. This is the bill that improves the organizational structure of the Department of National Defense. Am I correct, Mr. Chairman?
Yes.
Thank you, Mr. Chairman, just to clarify. Thank you, Mr. Chairman.
Adjournment natin. Is there any other matters, Your Honor, wish to discuss before we adjourn?
Mr. Chair, I move to adjourn, Mr. Chair.
Second,
Second
Mr.
the
Chair.
motion.
Your favorite motion. There's a motion to adjourn. Duly seconded. Any objection? Before we adjourn, let me thank again our members and our resource person for their invaluable contribution to the proceedings. There is a motion to adjourn. Duly seconded. Any objection? There being none, the meeting is adjourned.